Okay, we'll call to order this meeting of the Tennessee State Board of Equalization, Monday, October 16, 2023. Welcome each of you to the meeting. I'm David Lillard, Tennessee State Treasurer and Chair of the Board. The first order of business is we'll ask Mr. Pope, our Executive Secretary, to call the roll of the members.
Sure. Alphabetically, I have Miss Betty Burchett.
Here.
Commissioner Jaragano.
Here.
Secretary Hargett. I know he's absent. Miss Merrick.
Here.
And Comptroller Mumpower.
Here.
And Treasurer Lillard.
Here. Okay, Chair detects a quorum, and thank you for that roll call. Let's see, I believe we also want to ask at this point if there are any public comments on matters which are on the agenda for today's meeting.
Yes, thank you. On Friday, I sent out an update identifying those individuals who filed a request to make public comment, along with a copy of the board's resolution adopting parameters for making public comment. Board's public comment period is reserved right now at the beginning of the meeting immediately following the call to order and a quorum is being established. Before you should be a one sheet identifying the speakers for today, the agenda item they wish to speak on, and whether the speaker is in favor for or opposed to that said agenda item. Each commenter is to identify his or herself at the beginning of their time. They have 2 minutes per person per agenda item. The board may ask questions of any time, and any time used for questions shall not be subtracted from the speaker's allotted 2 minutes. And so for our speakers who are here today, I believe you were also copied on that list of that one sheet, so we'll go in that order. We make sure you speak in front of a microphone, and we have a table up here for our public commenters as well. For those commenters who we may have joining remotely, please be patient, and we'll work with you to make sure we can hear you once we get to your turn.
Okay. So the first person we have identified as a speaker here on Mr. Pope's list today is Dedrick Brittenham, attorney at law. Mr. Brittenham. Good to see you, Dedrick.
Good to see you, Mr. Chairman. Good afternoon, everyone. My name is Dedrick Brittenham. My office address in Memphis, Tennessee is 3385 Airways Boulevard, Suite 29. The only public comment I have to make is that I understand that Mr. Pope will discuss the procedure for processing the Shelby County appeals at item number 5. I'm representing the Shelby County Assessor. All the comments I have, Mr. Chairman.
Okay.
I tried to condense it to minutes.
Any questions of Mr. Brittenham? Seeing none, thank you very much. Next person we have on the list is Janika White, Janika N. White, attorney from Memphis.
I'm seeing from Mr. Brittenham that she is not going to appear today.
Okay, all right, so that'll be waived then. Next person is Sean Lynch from Memphis.
Good afternoon. Sean Lynch, attorney with Ryan Law, 1661 International Place, Suite 400, Memphis, Tennessee, 38120. I'm speaking against the exceptions filed by Shelby County in this matter. They are contesting the value placed on these property owners from OSAP. How this works is taxpayers fill out a schedule depending on which kind of state assessed property they are. That schedule is not made by the taxpayers. That schedule is made by OSAP. They fill it out, they send it in. OSAP comes out with a number based on what properties in the state, what properties in each county, what each municipality. Shelby, in its infinite wisdom, has decided to take exception to 43 taxpayers, not of all of any class. We don't know why they chose these 43. They just chose to essentially audit 43 taxpayers. On that, they say the current value appears that what they have the current value is wrong. The only evidence we have is a spreadsheet. Half of it's wrong. As they're all assessed at 55%. Only 4 of the 43 are assessed at 55%. The rest are 40 and 30, like everybody else. Then on their contended value, they've got a number that appears to be on 34 out of the 43, just 4 times whatever the state put on it. No reason, just it's 4 times what they put on it. It seems to be money grab, if anything. We'd ask that the state assessed properties, if those values be affirmed, If they're not affirmed, we would ask that we have some kind of bifurcated hearing to set aside, make sure that there's an actual issue and that Shelby County actually has a case to put forward before we make all these 43 taxpayers go through there's going to be extended discovery in this case. These are multinational companies. They're asking for every bit of information, every piece of property they have. If they're not affirmed, we need to know that Shelby County actually has some kind of reasonable basis to go forward with this before these taxpayers have to spend an inordinate amount of money to prove the state's value. Thank you.
Okay, are there questions of Mr. Lynch about his comments here? Members of the board?
One question.
Yes.
Which of those taxpayers are your clients? Are you?
Currently, Averitt Trucking, Old Dominion, and Intermodal Cartage.
Thank you.
Any other questions of Mr. Lynch in regard to his comment? All right, thank you very much,
Thank you.
Mr. Lynch. All right. Next person on the list is David Scruggs, attorney of Memphis.
Yes, thank you. Thank you for giving me an opportunity to speak to you. I'm speaking in regard to item 6, which is other business, which is the audit of the appeals pending. And I wanted to make 3 suggestions to you in regard to how the backlog of appeals could be reduced. The first is you should discourage and limit discovery. By statute, discovery in these property tax cases is supposed to be informal. Formal discovery impedes a hearing and is also a basis for harassment on either side. Minnesota and Florida have both enacted limited discovery and administrative appeals, and they limit that to the names of witnesses and written exhibits. And I think you should consider that. The second thing is enact annual reappraisal. And the reason why I say that is county boards of equalization will not act on a appeal that's pending before the state board in subsequent years. In other words, if you had a reappraisal in Shelby County in 2021 and an appeal was filed and 2022 comes around, the county board won't hear it. So you have to file another appeal with the state board. And that can add up to 3 or 4 appeals, which would be 3 or 4 hearings on the same property. If you had annual reappraisal, the county board would hear each year. And I believe you wouldn't have as many come to the state board. The last one is we believe the comptroller should act more in a mediation or mediation for resolution of disputes. Presently, the comptroller intervenes on behalf of the assessor. He's never intervened on behalf of a taxpayer. And the comptroller actually represents assessors in contested cases before the state board. Now, respectfully, we question both the propriety and the legality of that. But what we're making is a positive suggestion. We suggest that the comptroller could play the role of mediator in these disputes and encourage resolution. Evans and Petrie wants to find a solution because we want to serve all the thousands of Tennessee taxpayers we represent. And we're willing to have discussions with the state board, the Administrative Procedures Division, and the comptroller at any time to expedite the system of hearing appeals. Thank you for letting me address you.
Okay, any questions of Mr. Scruggs about his comments? All right, seeing none, thank you, Mr. Scruggs.
Thank you.
All right. Next matter to take up here is, I guess that concludes the comments, right? Rob?
Correct. There are no more timely requests for public comment.
Next matter here on your agenda is review and approval of minutes for the August 21, 2023 meeting. They've been attached to your materials. And any comments, questions, or revisions to the minutes? None. Is there a motion with respect to the minutes?
I'll make a motion to approve.
All right, motion by Ms. Burchett to approve. Is there a second? Second by the comptroller. Any discussion? Seeing none, since everyone's present, we'll just vote by voice vote. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it and the item's approved. Next item is review and approval of Greenbelt application forms and various manuals that have been included separately in your materials. Mr. Pope and others, a presentation on this.
Yes, Matthew Childress from our office will present for the first.
Okay.
Yes, good afternoon, everybody. Just very briefly, we've updated our office's Greenbelt manual to reflect current changes following this year's legislation, and that's just updating in terms of how our office handles those appeals. There were also some minor clerical and grammatical errors that were taken care of. So I'm happy to address any questions that you have in regards to that update.
We have a motion by the comptroller. Is there a second? Mr. Giordano seconds it. Any discussion? Seeing none, all in favor signify by saying aye. Aye. Those opposed, no. The ayes have it and the matter is approved.
We have several different manuals, so just want to clarify that was for our Greenbelt manual. We have our exemption. Sorry, that was for our County Board of Equalization manual. We then have our exemption, and then our Greenbelt exemption is also presented by Matthew Childress.
Without objections, clarified that motion applied to all of those manuals as read by Mr. Pope. Materials here.
Thank you.
Thank you, Mr. Pope. All righty. The next item we have is, let's see here, review and certification of the 2023 ad valorem assessments, public utility and common carrier companies as shown in your materials. There are 3 different action items here. Mr. Pope, you will be recognized on that of the staff.
Yes, there are 3 different distinct action items here, and these should be approved individually because they do involve a stepwise process to get to the final one. So our first is recognition of the Office of State Assessed Property staff for any recommended changes, and I believe Mr. Greg Moody is here presenting that item.
Moody?
Thank you, Mr. Chairman. I'm Greg Moody, Director of the Office of State Assessed Properties. We have before you recommendations for assessments for 13 companies, and these are based on amended returns, and it is also based on mostly amended returns. There's additional information. One of the companies closed, and the other ones are the companies that have finally completed providing all the necessary paperwork to be regular accounts instead of forced. And those are those 13 companies you have before.
Okay. All right. These matters that Mr. Moody spoke about are presented in your materials on pages 8 through 12. Any questions or discussion about those items at this point? All right. Seeing none, motion to adopt the changes as proposed by the Office of State Assessed Properties is in order. Is there a motion to that effect? All right, motion to adopt by the Commissioner. I'll second that motion. Any discussion? Seeing none, all in favor signify by saying aye. Aye. Those opposed, no. The ayes have it, and the matter is approved. Next item is item B, which is referral of matters requiring hearing. And the board may refer matters for initial hearing for the administrative law judge. Mr. Pope and the staff want to identify those matters and discuss any items with respect to that.
Yes, thank you. So the Shelby County Assessor has appealed, I think, approximately 45 public utility assessments performed by the Office of State Assessed Properties. We've notified the 45 companies of the appeals and of today's meeting. These appeals are currently set to be referred through the board's appeals process, similar to other valuation appeals. As part of that process, these appeals may be referred to an administrative judge for consideration in a possible contested case hearing. The administrative judge will be able to receive evidence and testimony regarding the basis for each appeal and making ruling as to the proper valuation of each assessment. These proceedings will be held under Tennessee's Uniform Administrative Procedures Act, and a record of the proceedings will be made by the administrative judge assigned to the appeal and the Administrative Procedures Division. The appeals will first be set for a scheduling conference with myself before eventually being referred over to the Administrative Procedures Division for a hearing. I've repeatedly said may, as with all other appeals, before the board, the parties may settle their appeal at any time, or otherwise the appellant may elect to withdraw their appeal before their hearing date. And with that, that is the typical standard process for these matters for public utility exceptions or appeals to the board.
Okay. Any discussion about those items as presented by Mr. Pope? There's the motion would be in order at this point to refer the appeals to an administrative law judge for further consideration. Is there a motion to that effect? Okay.
I'll second.
And a second by Ms. Burchett. Is there any discussion on that item? All right, seeing none, all in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. The matter is approved. Next item is subsection C, which is certification. discuss the draft certification of the 2023 assessments of public utility companies as submitted to by the comptroller September 1, 2023, and presented in your materials. Mr. Pope?
Yes, you should. If the entire packet is rather large, it's going to be that 85-page section about. You should have before you that final certification for this year's assessment of public utilities. That certification will be as amended from today's item 4A, and then subject to the outcome of the appeals as referred over in items 4B. And then that will entirely encapsulate the certification for this year's 2023 assessments.
Now, as to the comments that were made by Mr. Lynch here, to some degree by Mr. Scruggs, is there any issue with respect to any of that here with respect to this certification or other actions relating to these matters that the board should consider further at this point? If the staff has any comments on that?
No particular comment. I would say the standard operating procedure for the board for a number of years has been to refer these appeals over through the appeals process, where sometimes the appeals do fall out for various reasons, but that gives the parties an opportunity to fully explore those issues, the validity of any appeal, the timeliness issues, jurisdiction, kind of all of those potential legal issues involved with these appeals are then set before an administrative judge to fully examine and make a finding on the record. And so the appeals process would otherwise be the normal route for this agenda item. And so to the extent that the parties have concerns about these particular appeals, they can fully explore those with the administrative judge now that they've been referred over.
That in the chair's view, that would pertain to the comments made by Mr. Lynch, particularly in regard to the comments by Mr. Scruggs about his 3 points that he made. I don't know, of course, it's within the purview of the judge, I guess, to determine what degree of discovery is allowed in the proceedings, et cetera. So other issues that were brought up there. I guess it's just the question is just whether the staff's going to look at those 3 things again that Mr. Scruggs suggested. Any comments from the staff about that?
I believe, sorry, if I remember correctly, it was Mr. Scruggs commented on.
Well, he commented that the discovery should be limited and the annual, there should be annual appraisals, which is a different issue kind of, and that the comptroller's role with respect to the process and everything. So those are the 3 points that he raised. I guess what I'm just saying is asking the staff to look at those things further, you know, and consider those.
Absolutely.
Right. Okay. So we're on certification here, and the draft certification's been discussed and all. Is there a motion at this point to approve the certifications as presented? All right. Comptroller moves. Is there a second? Second by Commissioner. Any discussion on that? All right. Seeing none, all in favor of the motion signify by saying aye. Aye. Those opposed, no. The ayes have it, and the item's approved. Ready? Moving on here. Next item is review of appeal of the board review of initial decisions in order by an administrative law judge. It's presented on pages 128 through 149 of your materials. Mr. Pope, I believe, will discuss this.
Before the board today is an appeal asking for you as the board to review an initial decision in order on a property valuation appeal. Included with your materials is a copy of my letter to the parties identifying the appeal for board review would be on today's meeting, a copy of the written appeal filing filed on behalf of O&S Partnership, and finally, the actual initial decision in order for the appeal in question. A copy of the entire administrative record, including the audio recordings of the appeal, were sent to you via that Microsoft OneDrive in advance of today's meeting. The board has several options with regards to this appeal. You may 1, review the appeal in its entirety. 2, review some, but not all of the issues raised. 3, you may delegate your authority to review to 1 or more persons. 4, delegate that review subject to final approval by you as the board. Or 5, otherwise decline to exercise review, essentially providing no comment and allowing the parties to appeal to Chancery Court if they so choose. You may, but are not required to, hear oral arguments from the parties before making a decision. But first, you must make that decision if you want to grant review or decline review or some other option. If you want me to elaborate on any of those, please let me know. Alternatively, the board may also choose to defer action until next meeting if you would like additional time.
Okay, the chair will volunteer. I have looked at the record on this and read the materials and everything, and listened to some of the proceedings and all, and I did not see anything that merited us doing anything other than declining to review. Would be my personal comment on that. So, is there anything from the staff that would recommend otherwise?
It's certainly not my appeal. The parties are aware of today's meeting. If you would like to have oral argument on their petition, but I have no comment on the appeal. I did not make this determination or anything like that. Just presenting the process for board review.
I guess I'm pointing out that from my perspective, the record states in effect that there was a full and fair review and done decision made by the judge involved in the matter. And so I don't see any reason to do anything other than decline to review the matter. This board. I'll move that.
Second.
All right, we have a second for that motion by the comptroller. Is there any discussion on that? All right, seeing none, all those in favor of the motion as made will signify by saying aye. Aye. Those opposed, no. You guys have it. And the matter is, my motion is approved, so we decline to review. All right, next matter is other business here on an informational item. Mr. Pope.
This is purely informational, and for those especially in our gallery, immediately following our regular meeting will be the audit committee, where I'll present a board update and staff update of our operations over the past year. So just please be mindful, as we will convene that immediately following this meeting. So if you're welcome to stay and observe. It is a public meeting, but we will try to get that started. So if you could keep your chatter to a minimum so we can go ahead and get that done, that's all I would politely ask. Other than that, that concludes all our regular agenda items other than adjournment.
Okay. I'm sure the audit committee meeting will be terribly exciting, so everyone should want to appear and see that. All righty. Any other business to come before the board at this point? Seeing none, the chair would move that we adjourn. Second. We have plenty of seconds. All those in favor signify by saying aye. Aye. Those opposed, no. We're adjourned. Thank you for your service to the board and to the state of Tennessee.